Hello, welcome. David Brannen here to Ask a Lawyer Live. Today is Wednesday, June 4th, and I'm here to answer your questions. We're going to talk a little bit today about our topic is refusing unsafe work conditions. This is always a difficult dilemma that people face, but it could prevent you from injuring yourself or save the life of a coworker. So it is important to know about what your rights are in terms of refusing unsafe work conditions. Now, this is something that's more common than you might think in Canada, whether it's like it can be things like faulty machinery, toxic substances, or being asked to do something beyond your physical limits that could result in an injury. These are all situations where people can get seriously injured, and so it is important for you to know that you can refuse these situations in terms of being asked to do the dangerous thing. Now, you do have a right to say no, but it's important that you follow the right legal steps so that you don't put your job at risk. So you have to refuse when it is appropriate to do so and do it in the right manner to make sure that you don't get fired from your job basically for refusing to work. So what is considered unsafe work? The law says you can refuse unsafe work when you have a reasonable belief that doing it could cause you to hurt yourself or someone else. Reasonable belief obviously is a loaded term, and so this is why it may be helpful to get legal advice to figure out if what you believe would meet this legal threshold of a reasonable belief. It doesn't mean you have to be absolutely right. It just means that a normal person with your knowledge and experience would think that the situation was unsafe. Okay. Examples include that equipment that's broken or not maintained. That's one I've seen in my own work with clients. Working at heights without fall protection is a big one. Exposure to chemicals without the right protective gear. I've seen that one in my work. And trying to get you to lift things that are beyond your physical capacity to safely lift them. Those would be things where you would be able to refuse to work. Now, who is covered? Pretty much any employee in Canada is going to be covered, whether if you work for a provincially regulated employer, which is most people, like that would include things like construction, retail, healthcare. You're covered under your Provincial Occupational Health and Safety Act is where you would go to find these protections. If you work for a federally regulated employer like banking, airlines, telecommunications, Canada Post, etc., you're covered under the Canadian Labor Code. That's where you would find those protections. The process is slightly different depending on where you work, but the protections are all basically the same in Canada. So a process that you would want to use to, if you are faced with an unsafe work situation, tell your supervisor immediately. Don't just stop working and leave. You definitely have to report it and make sure that there's a paper trail and a record of it. Number two, you want to stay at work but move to a safer place. You can't be forced to do the task that you are refusing to do, but you also just can't walk off the job. So this is where you have to use some judgment, move to a safe area, let the supervisor know. You can't just sort of up and leave the job. Step number three, your employer must investigate the issue. This is required under the Occupational Health and Safety Acts and the Canadian Labor Code. So this usually happens immediately. If you're not satisfied with the results of the employer's investigation, you can bring it to your employment also has to have a health and safety representative. You could bring it to that representative. All workplaces have to have that person. Now, if it's still not resolved, then you can report it to your provincial or government safety inspector. They'll have to be called and come out to the work site to look at the issue that you're complaining about. So you would have to report it to the Occupational Health and Safety organization for your province or to the federal government, and they would send out an inspector to come see to resolve the issue. Now, while you wait for these investigations, your employer just can't force you to do anything else. They can't just send you home or make you do the dangerous work. They can assign you other work as long as it's safe and appropriate. They can ask another worker to do what you refused, but they must tell the person of your refusal and why you believed it was unsafe. So the employer does have an obligation to do that. Now, can you be fired? Absolutely not. You can't be fired if you have a legitimate complaint. Now, you have to make sure that you have a reasonable belief for your safety here and that you're not stretching the truth or have any kind of ulterior motives. So, assuming you're not trying to stretch the truth or have ulterior motives, then you will be absolutely protected here. The law makes it illegal for employers to have reprisals against people or to fire you or suspend you, demote you just because you've raised safety complaints. Now, that doesn't mean that employers won't try to do that and blame it on something else like restructuring or some other thing. But if there is some type of reprisal like this, you should bring it to the light with your provincial labor board or labor program if you're federally regulated and get legal advice, because cases where employers have done reprisals, you are entitled to more damages in those types of cases beyond the normal kind of termination and severance pay that people get. We handle cases where there have been reprisals on top of someone being fired, especially if they've reported some type of difficulty. Now, I won't lie, it is sometimes hard to prove these safety violations. There are steps you have to go through. It can be difficult to prove. So you do have to follow through. If there's an investigation with OHS, Occupational Health and Safety, whoever it is, you do have to follow it through and have present evidence to the investigator to satisfy them that there was a safety concern. All right. Now, what if you get it wrong? So this is a common concern that people have, obviously. Again, the answer is that you're still protected as long as you acted reasonably and had a reasonable belief. Then it won't matter that you were wrong in the end, that this wasn't a safe thing. The law protects good faith refusals of work, and so that you would be protected in these situations. Now, real life example, this is one I've actually seen myself. So let's say you're a warehouse worker and told to operate a forklift that had faulty brakes. This is something I actually saw myself when I was a young worker working in a warehouse. It wasn't me, but someone else reported it to a supervisor, stepped aside. They stayed in the break room until the supervisor had it investigated and had a mechanic come in and fix the brakes that were in fact worn out. Now, this is just an example from my own work history. Everything got fixed. The workplace I worked at was fantastic. There was no issues. They got it fixed, but it was a known issue with that forklift, and it did turn out that the brakes were not working properly. That's how it's supposed to work. You inform the workplace, they get someone to look at it and get it fixed. All right. Now, federal versus provincial rules. Again, the core process is the same across Canada, whether you're working for a federally regulated industry or whether you're in a provincially regulated industry. You just have to figure out which one you are. You can get legal advice if you have difficulty. Sometimes it's not clear. In fact, I was working on a case today where we're trying to figure out if we should be filing the human rights complaint with the provincial body, the provincial commission, or with the federal commission, because it's some type of organizations. They have a mix where some parts of them are federally and some parts of them are provincially regulated, federally regulated. So there can be these cases where they fall in between. In those situations, you just have to get legal advice or call the department itself and ask if they feel like your employment should fall under their provincial jurisdiction or federal jurisdiction. Now, if you need help, you can document everything. That's the most important thing. Document. Oh, did I skip over something here? No, I didn't. Document everything. File a reprisal complaint if you think you've been punished for doing the right thing and refusing to work. And you can always contact a lawyer for legal advice. Final tips. So just don't walk off the job. That is something some people will do, is just walk off the job or, get angry. We've had people we've had to advise about this. We've had people quit over this. I had a case I'm still working on where it's complicated because it led to a situation where, the person quit and basically told everyone to, where they could go, and F you to you, F you to you. So that kind of situation is not great, because when you quit, you're not entitled to any money. And if these occupational health and safety investigations don't go your way, and many don't, because sometimes it's hard to prove things, that you can then be in a situation where you're not entitled to any compensation. So you want to follow the steps that I outlined. You want to keep detailed notes. And if you're unsure, talk to your organization's occupational health and safety rep or reach out to for legal advice from a law firm like us or someone else. Certainly, you can get in touch with us for cases like this. We have free consultations with workers. These consultations are with our support team, so they're not lawyers, but they'll be able to give you a basic overview of what your options are. And if it's a situation where we think we can help, then we can provide more detailed legal advice, or we have paid options where you can just pay us to give you legal advice, even if we aren't sure if we can take on your case for full representation. All right. And we do serve clients across Canada, pretty much everywhere, not necessarily in British Columbia, but anywhere from Alberta east. We pretty much will work in all those provinces. Okay. Now, that's it for my main topic here. I'm here to answer questions if people have them. I see we have a few people watching. So if you have any questions, now's a good time to put them in the chat. I already checked. Normally, I like to go through my Canadian Disability Forum to see if there's actually questions in there. It looks like there's no new questions from yesterday, so I won't do that. I also checked up on the Canada Disability Benefit to see if there's anything new, and it appears there's nothing new, unfortunately. We're still waiting right now to figure out when is this application process going to start. And as of today, I don't see anything, honestly. Let me see here. Don't see anything yet, unfortunately. So the last thing that happened was that the regulations came into force in May. So the program is live and going, and the application process is to start in June. So we're in June. The applications are supposed to start in June, but we have not seen them yet. One thing to keep in mind is if you have access to Service Canada online, you may want to just keep an eye in there. I have a high suspicion that that is where the applications are going to be done within My Service Canada. So just keep an eye in there. At some point, there's going to appear, could happen any day now, there's going to appear an option for the Canada Disability Benefit. You'll click on it, and there'll be a way for you to fill out an online application. I'm almost certain that's how it's going to happen, just based on what I would expect from Service Canada, how they're going to handle this. If you haven't already done so, and you do need to apply for the disability tax credit, if you haven't already done so, that's a criteria to be approved for the Canada Disability Benefit. So just keep that in mind as well. Okay. Not much other news. I've had a fun week. We've had a new person start with the firm. It's someone who is she's working on getting her to become a lawyer, basically. So I'm not sure how much people understand about how it works with lawyers in Canada. But in Canada, once you graduate from law school, you are not a lawyer. You are just a person with a law degree. To become a lawyer in Canada, you need to do two things. You have to complete a year of apprenticeship with a law firm or an organization that has a licensed lawyer there. So basically, the new person needs to work under a licensed lawyer for a year with a direct kind of supervision and do something that's called articling clerkship. It's a weird kind of name, but it's really just an apprenticeship like you would see with any other trade. That person started with us this week. She's been great. It's been a lot of fun having her around. And so I've been working with her a lot the last 3 days, getting her up to speed on things. It's good seeing someone else's perspective who's just fresh out of law school. The way it works with lawyers is they have to do this for a year. And then at the end of the year or near the end of the year, so she'll be doing this until next June. I think by September, October, that she will have to write the bar exam. Most people have heard what the bar exam is. That's the test, a written test you have to write to actually become a lawyer in Canada. So to become a lawyer in Canada, you have to pass the bar exam and also pass the articling clerkship, which is a practical apprenticeship. So she'll be working on both of those things. It's a big achievement to pass both. They're both difficult. Some people don't pass they don't pass the bar exam. Obviously, that has a not as high a failure rate as in the United States. Has a much higher failure rate with the bar exam, just because there's so many more law schools. There's fewer law schools in Canada, so the quality of the people is typically higher in terms of their abilities and things, just because there's less people getting in and stuff like that. So there's a lower failure rate in Canada for the bar exam. Generally, I think that's still true. And most people pass the practical component. The bar exam is the harder component to pass, although some people do struggle with the apprenticeship part. But yeah, it's always fun to do this. And hopefully we wish her all the best with us. Maybe I'll have her on. I'll get her on maybe as an interview here. Let's not get her on here right away, but if she's willing, we'll get her on the show here just to discuss different issues and things like that. Now, just checking to see if anyone has questions about anything at all, or if you're just watching to see what happens. It's always something can happen on here. Usually my mic not working is usually what happens. Okay. What's new as well? I'm trying to think of things I've been working on this week. What's new? Anything interesting to talk about with people? There is a few things I've been working on that are kind of interesting. I had a case today where I spoke with someone. I'll just be careful not to give any details, but it's common that we will get contacted by people who've been given an offer by their insurance company for a settlement. So I did talk to someone today so what happens is people will call in, say, look, my long-term disability is offering me a settlement. I just need to know, should I take this? What should I do? So we don't negotiate those types of settlements for people. This is someone on an approved long-term disability claim, and they've been given an offer from their insurer. So people will pay us to do an independent legal advice. And in fact, the insurer will usually reimburse most or all of our fee. And what I do is the person gives me all the details. They give me the offer letter from the insurance company, the release that the insurance company wants them to sign. And then I talk to the person and go through and basically give the pros and the cons, what the implications are if they take this deal. Is it a good deal? Is it a bad deal? I try to help them work it through and make a decision on whether it's right for them to accept this settlement and close this. This would be a buyout. Sometimes people call it, whether it's worth it for them to buy out their claim, pay for the buyout, or not. Right? Because when the insurer contacts you about this, it is a voluntary thing. They're offering it to you. You don't have to take it, but sometimes it's very tempting to do so. In this case, there's different ways the insurer will do it. In this case, the insurer was offering a buyout until this person would get to the end of their own occupation period. So this person was older, so like their own occupation period would end within, say, sometime next year. Then they would have another 5 or 6 years or so after that of potentially being available. So they're in their late 50s, so they would have potentially 5 or 6 years after the own occupation period ended and to have benefits from any occupation period. So what I was explaining to them is like what they're offering you is just up to the end of the change of definition. They're just going to pay you out until the change of definition. Then they're going to take the view that you should be able to go and do other types of work. They're agreeing you can't do your own occupation, but they're going to say, we think you should be able to do other. So we'll just pay you out now up until the end of the own occupation. And then you're signing a waiver, you're signing a release that we're going to pay it out to you now, but you can't be entitled to anything beyond that. Generally speaking, that's not a great deal because they're going to have to pay you until the end of the own occupation period anyway. So why sign off all your rights? That's the kind of thing that I would talk through with a person like this. Like, they're just going to pay you out. They're only offering to pay you out until the end of the own occupation. They're going to pay that anyway. So why not just let them pay you over, from now until then over the next several months? They raised the idea like they just went through the headaches of a return to work. There's already talk that they still will have another person working with them about training and returning work. They just don't want to deal with all that. So they would rather just be done with the insurance company. And that's fair enough. Fair enough. That's why people make their own choice. But they would be giving up a potential lot of money from beyond when you get into the own occupation period. It was a significant amount of money, hundreds of thousands of dollars, several $100,000 that they'd be giving up of potential benefits once they get into any occupation. Now I explained to them, like, you're not guaranteed that you would, like, it's clear that you can't do your own occupation. It's not 100% clear that you won't be able to find other work that therefore you wouldn't be entitled to benefits in the any occupation period. So if that's the case, then you wouldn't be entitled to more than what they're offering you anyway. But if there was a possibility that you couldn't work enough to earn enough money to get you over the threshold, so there's a financial threshold once you get into the any occupation period. In this person's case, it was pretty high. In this person's case, I won't say the exact number, but it was, well, we'll just say it was $50,000. That's not what it was, but we'll just use that as an example. So if this person did not have the capability of earning $50,000, then their insurance company would have to top them up. So, for example, if they could only earn $30,000 because of their disability, the insurance would have to top them up with another 20. What I explained to them is that that's in theory what would happen, but the insurers are never going to do that. They'll just refuse to pay and say you should be able to work and earn 50. They don't care that you're earning 30. They think you can work more. You end up suing them. Now we're suing them for the $20,000 a year that they're not paying you. If it's 5 years, that's $100,000. By the time you negotiate that, maybe we negotiate it for 75,000. You pay the lawyers, taxes. Well, there would be no taxes. You pay the lawyers, and then you would have, I don't know, $40,000 left over. That's still a lot of money. Obviously, I would take $40,000 if someone gave it to me, but that's like, if everything goes well, that's a very good result that could happen from all this. And they were just, I think when I was talking about, you'd have to do this, you're going to sue them. There's this, it just sort of, they're like, you know what? I don't want to do any of that. I'm just thinking I'm going to take the settlement and be done with it, which is a completely valid thing to do. If it was going to be completely clear, like, I would have really argued them. If I thought that they were not going to be capable of working at all, I would really stress to them not to do this deal, because you're giving up so much money. And if you can't go back to work, unless you're financially independent, then you have to be really careful about taking a deal like this. Oh, we got a question here. It says, if a person takes a buyout, does that mean their employment ends as well? Very good question. I'm glad you brought that up, because that was the other side of the conversation we had. A part of the offer from the insurer was that if you accept this offer, we inform your employer about it. And what I told this person is that when they inform your employer is likely to start the process of terminating your employment for frustration of contract, because they're going to inform the employer that they're paying you out until the end of this own occupation. The insurer is going to acknowledge to the employer that this person is disabled from their own occupation. That is evidence that the employer can now rely on to terminate someone for frustration of contract. So I told this person that it was highly likely that if they take this deal, that their employer is likely going to fire them as well within a short period of time. Now, one of the benefits of taking a deal like this, so what I explained is, okay, now if you reject this deal and just keep getting disability benefits month to month, and your employer fires you in the meantime, then any payment from the employer is going to be subtracted from your LTD benefits. There's going to be an offset. You won't get to keep both. However, if you take this deal, if you settle this case tomorrow, you take the buyout offer from the insurer, and sometime after tomorrow, the employer also terminates you. This person lived in Ontario. So in Ontario, if you're terminated for frustration of contract, you're still owed statutory termination pay and severance pay. And this person had worked there quite a long time, so they were entitled to a significant number of weeks of pay. So it's going to be a lot of money. And I told them, like, you now get to keep that. So if you do this settlement, yes, you're getting less money overall than you potentially might get, but you also now get to keep the settlement that you're going to get if your employer terminates you for frustration of contract. So that's a bonus. So you got to work that in. Now, maybe it's worth it if you do that, because if you don't take this deal, you stay on it, and we're fighting the case against the insurer, and you, in the meantime, get this settlement, the insurer is now going to include that as part of the negotiations, that they're going to take it off. So at the end of the day, that maybe that's the best way to go. But just to answer the question, Mania, taking the deal does not directly terminate your employment, but it will lead to the termination of the employment in most cases. That is the practical thing that will happen. This person also had a question about, well, what happens with if I take this buyout, what happens with my medical plan, like for my drugs and dental and all that? And I said that that has nothing to do with taking the buyout from nothing directly to do with taking the buyout offer from the insurance company, because the LTD is not paying your medical plan. Your medical plan is still separate and you're only settling the LTD component. You're not settling out all of your group benefits. So your other group benefits would continue as long as you're employed and enrolled in the plan. But when the employer terminates you for frustration of contract, your plan would then come to an end. Not immediately, because if you're in Ontario, if you're lucky to be in Ontario, they do require the employers to still pay termination pay and severance pay. So in this person's case, there's going to be many, many weeks, like dozens of weeks, or a couple dozen weeks anyway, where they would have notice and severance period. And so during the notice period of 8 weeks or more, they would still be entitled to get their benefits. So they couldn't even terminate this person's benefits immediately upon, at least in Ontario, for a frustration of contract. The benefits would still need to be paid during the notice period, which in this person's case would have been a minimum of 8 weeks. So they would at least have 8 more weeks of benefits where you could get your medications in, make sure you get to the dentist or do anything else you had to do before the benefits went. All righty. Wow, I'm talking a lot, but I am going to yep, those are all the questions. So if there's no other questions, I am going to shut it down for today. I am going to go take care of a few things. I'm also getting ready to go on a big hike later this summer, 3-day hike through Cape Chignecto, Nova Scotia. It's a pretty big hike, and I need to get ready for that. I'm starting to get all my gear together, training and all that kind of stuff. So I'm not sure if there's any hikers on here, but that's a fun thing for me to do. I enjoy it quite a bit and looking forward to that. So I'm going to take off for now. Hope you guys have a good evening. Not sure if there's going to be a show tomorrow. There may not be, just due to things I have going on with my workload. There won't be one on Friday, so we'll be back Monday for sure, but there's a possibility that there won't be a show tomorrow. I do wish you guys all the best, and we'll see you back here next week. Take care.